What are the historical origins of data privacy rights? Imagine a world where your personal information is open for anyone to see. Now, think about how society has fought to keep some of that information private over centuries. That's what data privacy rights are all about. They didn't just pop up overnight. They have a long history rooted in protecting personal space and information. Long before computers and the internet, privacy was about physical spaces and personal letters. Laws against eavesdropping and unauthorized opening of mail date back hundreds of years. In the United States, concerns about privacy appeared early on. When the first census was taken in 1790, many people worried about exposing private family details. They feared government overreach and loss of personal control. The idea of privacy as a legal right became clearer in 1890 with an article titled "The Right to Privacy," written by Samuel Warren and Louis Brandeis. They argued that people should have legal protections against invasive technologies like instant photography and sensational journalism. They emphasized the right to be let alone, which shifted focus from just physical privacy to controlling personal information. During the 20th century, privacy rights grew stronger as technology advanced and governments started collecting more data. The U.S. Constitution, especially through the First, Third, Fourth, and Fifth Amendments, provided a foundation for privacy protections. The Fourth Amendment, ratified in 1789, forbids unreasonable searches and seizures, giving people some control over their personal property and information. In 1914, the Federal Trade Commission was created to oversee fair business practices. It started regulating privacy issues related to commercial activities. Later, laws like the Freedom of Information Act in 1967 allowed people to request government-held information about themselves. The Privacy Act of 1970 set rules for federal agencies on how they collect, use, and share personal data, requiring transparency and fairness. Internationally, after World War II, privacy was recognized as a basic human right. The 1948 Universal Declaration of Human Rights acknowledged privacy but was not legally binding. Germany took the lead in creating data protection laws in the 1970s, focusing on giving individuals control over their personal data. This idea is called informational self-determination. The rise of electronic communication brought new laws. The Electronic Communications Privacy Act of 1986 protected electronic data from unauthorized interception. Later, the Health Insurance Portability and Accountability Act of 1996 introduced strict privacy rules for health information. For small businesses, understanding this history is important. It shows why laws about privacy exist and how they affect handling customer and employee data. Staying compliant means being transparent, securing data, and respecting individuals' rights to access or control their information. Knowing this history helps small businesses keep up with evolving privacy rules, avoid legal trouble, and build trust with customers.